The fourth component that we're going to look at is discharge. This is the process and the analysis of contracts coming to an end. We're going to look at how individual obligations in a contract come to an end and what the consequences of contracts ending is going to be for each of the parties. Now, this screencast is broken up into roughly 9 areas, some with significantly more depth than others. But fundamentally, we're going to start by going through 6 different mechanisms that contracts can come to an end. The first through performance, the second through breach of some sort, the third through repudiation of the contract, then discharge by agreement. We're going to talk about the Doctrine of Frustration and the operation of law and how that can discharge contractual obligations. Then we're going to look at the remedies that parties can seek where the other side has done something bad throughout this process. We're going to look at the basic rules of common law damages and really the limitations on those as well, and specific rules to go about analyzing, claiming, and calculating those. And then we're going to look at the rules of equity and how they relate to the contract in situations where regular damages, money awards, just really isn't going to cut it. The first rule that we're going to start with is, I guess in many ways, the most straightforward. It's performing the contract. Basically, where two parties come together, create a contract with a series of obligations that each side promises to undertake. The simplest way that a contract can come to an end is if both sides complete all of the obligations. In other words, they do what they said they were going to do. Now, the starting point with analyzing whether or not parties have completed their contractual obligations is this idea of exact performance. And this is really the idea that in order to discharge your obligations, you have to follow the letter of what the contract says and complete them. Now, this, as you can imagine, can lead to some pretty harsh results. And so this 18th century case of Cutter and Powell was a situation where a crewman agreed in a contract to sail on a boat as a crewman from England to the Americas and back. And on the return trip, he actually passed away. And so his widow was trying to sue under the contract. And the ship company said, well, no, he didn't complete his contractual obligations. And in that situation, Cutter and Powell, the court agreed. And they said this particular contract required the party to complete the entire set of obligations in order to be discharged. Now, as you can imagine, this is a pretty harsh rule. And so the courts have developed some mechanisms really for trying to smooth these things over. The first one we'll look at is the de minimis rule. And de minimis, just as a term, is actually applied broadly in different areas of law. And fundamentally, it means the law does not concern itself with trifles. In terms of contract law, what that means is that very, very small variations in contractual performance are just not actionable. Now, the example here in Shipton Anderson and Wheel Brothers was a large shipment of wheat, about 700 tons was to be shipped, and the amount that was supplied was over by about 25 kilos. And the seller in that case didn't even mind. Essentially, they weren't charging any extra for that. But the buyer still, because it's strictly speaking, performance wasn't absolutely exact, purported to try and terminate the contract as a result of that breach. And the courts essentially sided with the seller in that situation, said, look, this is an absolutely trivial amount relative to the size of the entire cargo, and as a result, we're not going to find that the seller in this situation is in breach at all. Now, one of the themes that I've sort of brought up recurringly through these screencasts is the idea that the courts at common law are not the destroyers of bargains. Basically, the courts, wherever possible, if they can construe that there is a contract, will uphold that bargain and hold the parties wherever possible accountable under those contractual obligations. And so one of the, I guess, the exceptions or developments of this rule of exact performance is the idea of divisible contracts or severable contracts. And the idea is that if the contract logically can be chopped up into performance from both sides, usually in terms of one side performing in terms of supplying goods or services, the other side paying payment, then the courts, if there is some difficulties with the contract, can construe it appropriately. So for example, if you were to supply 10 pieces of lengths of fencing for $100 each, the entirety of the contract may be for $1,000, but if, for example, 8 of them were supplied, the courts will look at that and say, well, this contract is easily severable and divisible, so just make it $800. It also means that the contract in these situations can be analyzed in terms of other areas by splitting them into separate obligations. So for example, again, if you did deliver 8 lengths of this fence, that component of the contract can be discharged, and the other party can still sue for breach for the other 2 aspects or 2 parts of the fence that have not been performed in that circumstance. Fundamentally, though, this idea of severable or divisible contracts, it's really a matter of common sense. If the contract can logically be chopped up, then the courts are quite willing to do so. Another mechanism the courts use, again, to try and uphold the bargain wherever possible, is in situations where one party is due to perform and the other party usually is doing the payment in relation to that performance. And the party that's actually doing things, either supplying goods or supplying services, has done most of what they needed to do. In other words, they've substantially performed their side of the contract, but there is some form of defect that needs remedying, a minor defect that requires usually a small amount relative to the size of the contract in order to be fixed or remedied in some way. The courts, what they can do is to just award the reduction to the party that's paying. In other words, the party that is paying will simply not have to pay the full amount. The contract is still upheld, and both sides will discharge their obligations, but the paying party can withhold from payment the amount that they're going to have to spend in order to remedy those defects. An important thing to note about this this rule of substantial performance is that there's an aspect to self-help involved here. And really, if we think about that in a very pragmatic commercial sense, it is not uncommon for parties to sort of disagree about the final aspects of performance of a contract, again, either for goods or services or a combination of the two. And fundamentally, this rule is designed to try and keep parties out of the courts. In other words, that when parties do run into difficulties in terms of really trying to judge whether the one party has fully and completely and exactly completed their obligations, or there's going to be minor remedial work, in theory, the parties can resolve these things amongst themselves. However, reasonable people do from time to time disagree. And in the case of Honig and Isaacs, there was some renovation works to a building that had been contracted for. Now, the person, I guess the person paying in this situation, sort of realized that the amount that they'd bargained for was quite a lot. And so the person who was doing the renovation had probably got the good end of this particular bargain. And so when the work was complete, again, the paying party refused to pay the full amount. And they went to court, and there the court said that, look, in this situation, yes, performance wasn't exact, but you can deduct just a little bit in terms of for the amount of money that's required to remedy in that situation. And this is contrasted with Bolt and Mataviva. There was an air conditioning type of system that was put in, and it really didn't work particularly well. There was quite a fundamental failing with the system in its entirety. And there the court said that, look, this isn't a situation where a little bit is going to be able to remedy this. There's something fundamentally here. And in terms of the parties, the performing party here doing the installation hasn't discharged their obligations through the rule of substantial performance here. Another exception to this idea of this very strict exact performance is what happens when one side starts to perform but doesn't complete the work that they've contracted for substantially. Now, if the other side voluntarily chooses to accept the work that that party has done up to that point, then the side that's done the work can actually claim a reasonable amount for the work that's done. But the really important caveat here is that the other party, the innocent party in the situation, has accepted that the other side hasn't completed all of the work and has voluntarily chosen to accept the work that's been done. Some other exceptions to this idea of exact performance comes when the other side to the contract actively tries to thwart the performance of one side. Now, the key part here is that, look, if the other side takes steps to stop you from completing your obligations, then you can simply sue them for breach of contract. Now, in situations where there is a contract for goods of some sort, and the payment is going to be dependent on the delivery of those goods, and the other side wrongfully just refuses to accept those goods, that point, the performance is actually deemed to be complete at that point, and the seller in that situation can sue for the non-acceptance of the goods. Another situation can arise when one party says to the other that, look, it's pointless for them to continue because we're not going to accept it. We're not going to accept your performance from this point forward. In that situation, if the other side has actively said this to you, then you don't need to tender. Your performance is deemed to have been done at that particular point. So I guess from a pragmatic commercial perspective, it's important to note here that it's not uncommon for parties or for people to say to other people, hey, it's pointless for you to actually do this because we don't have a contract, in situations where there is a contract, and the person refusing to allow one side to perform in that situation doesn't understand the fundamental rules of contract and contract law. And so it's really important to note this. If the other side says that don't turn up or don't perform your side of the contract because we're not going to accept it, if there is a contract, then you don't have to tender your performance, but the other side is still in breach, and you can sue at that point, seek some form of compensation. One thing that can impact performance and parties trying to discharge their obligation through a performance are these specific type of terms called conditions precedent and conditions subsequent. Now, first thing to note is that the word condition is not the same as what we're going to analyze and talk about later in the screencast in terms of the test of essentiality and contractual conditions there. A condition precedent is essentially a trigger. It's a point in time where obligations arise. So that can be an event. For example, a contract to unload a boat, for example, clearly won't arise in terms of performance from the guys that are doing the unloading until the boat actually arrives. That's an example of a condition precedent. A condition subsequent is the reverse of this. It is an event or a point in time or an aspect of a contract that causes obligations to dissolve. They disappear at the time that the event happens. So an example of unloading a boat, keep unloading the boat until the captain says that it's going to depart. And at that particular point in time, in theory, the contractual obligations that you might have arranged at that point will dissipate. You don't have to perform that aspect of the contract at that point in time. Now, the key thing to note about contingencies is that they're not permanent. A contingent condition is simply not going to last forever. And so in that sort of situation where these things end up actually going to court, the courts basically just construe that, look, what is a reasonable length of time going to be before the particular contingency is going to dissipate? And they, when doing that, again, they look at the circumstances of the case. They look at the industry, the parties, what the parties intended as part of the contractual arrangement, and a good helping of common sense. The next aspect to do with discharge of contractual obligations is breach. This is a really important aspect, an important area of contract law. Breach of contract occurs when either one or both sides to a contract demonstrates either a failure to perform or an unwillingness to perform some or all obligations under a contract. And the key thing to note here with breach of contract is that the innocent party is always entitled to sue. Now, later in the screencast, we'll talk about the amounts that parties can get as the result of bringing an action and suing for damages. But the starting point is, though, any breach of contract entitles that innocent party to get something from the other side. Now, when determining what form of remedy or rights that the innocent party gets when the other side does commit a breach of contract depends on the type of breach. And so when we're analyzing a contract and we're looking at the breach, the starting point is that the terms or the obligations that are listed on the contract are really sorted into two broad areas. The first are what we call contractual conditions. Now, a condition is something which is fundamental to the contract. And the technical definition here is that it's so fundamental, so integral to the contract, that one or both of the parties would never have entered into it if they weren't going to be guaranteed sort of near perfect performance of that term. Now, the corollary of this we call contractual warranties. These are terms that essentially just don't give the other side a right to terminate the contract. They give dollars. So the innocent party in that situation is entitled only to dollars, but does not get the right to terminate the contract. The name of this test comes from Luna Park and tramways. It's called the test of essentiality. And again, it's that analysis of whether or not a particular obligation is so core, so central to the contract. And if so, then it is going to be a condition. Now, I guess the next sort of logical step to look is that, well, what about terms that perhaps are very, very important if there's a serious breach and not so important if there's a minor breach? Now, we call those intermediate or innominate terms. And so have struggled with this over the years. And fundamentally, though, they are allowed to examine when determining whether a particular term is an intermediate term or whether or not the particular breach that's occurred is so serious that it's essentially to be treated like a condition. They look at both the consequences of what has actually happened after the event, but they also look at what the parties, again, what they would have thought at the time of formation as well. It's also worth noting here that in some situations, it's not that a particular term has had one serious breach. It can, this idea of this things being an intermediate term and the seriousness of breach can actually occur where you've got a pretty unimportant or non-essential term, but there are many, many breaches. So in that situation, the courts have said that, look, this may actually go to the core of the contract, and as such give the innocent party the right to terminate, as well as the right to seek damages as well. Now, the classic example of one of these innominate terms is time. Now, parties can put into their contracts, they can very, very clearly specify that time in the performance of obligations is absolutely critical. And the examples here are Re-Ronem and Union Eagle and Golden Achievement, and both of those situations involving the conveyance of real property, of land and buildings. There were very specific times that were placed for settlement, and in those times the defaulting party missed that deadline by a really small amount, sort of 10 to 15 minutes. But in those situations, the court said, well, too bad. The time was of the essence in this contract because that's what the parties agreed to. If the parties, however, didn't agree to specific times, and the courts just look at, well, what would a reasonable length of time be? And in that situation, the aspect of time is going to be in non-material. In other words, a minor breach of time, taking a little bit too long, is going to allow the innocent party to claim damages only, whereas a serious breach, something that absolutely goes to the core of the contract, in other words, a massive overshoot of time, will allow the innocent party to both terminate and seek damages. Now, in some situations, the parties might not agree to time, and they may not discuss whether or not time is of the essence or not. But in some contracts, look, it's only logical that time actually is of the essence. And a classic example of that, of course, is perishable goods. If you supply a pallet load of ice cream to be delivered to a certain non-refrigerated location, it's quite logical to think, well, if there's delay in terms of doing this, in terms of picking up and performing in some way, that those goods are going to suffer serious damage. And certainly there are, I guess, more sort of abstract situations. Packets of shares, for example, that are bought and sold in exchanges. Time can, even if it's not made of the essence at the time of formation, sometimes the courts look at it and say, well, look, logically, it had to be in those situations. Also note that when the parties come together to form the contract, time might not be of the essence. However, a party to a contract can actually make time being of the essence by giving notice. So they can actually usually serve documents to the other side to saying, hey, look, from this particular point, we wish time to be treated as being of the essence. And the courts have mapped out some rules for this. That idea that the party issuing the document has to be doing it to the other side, who has to be in default. And the party issuing has to be ready and willing, able, so ready to go with their aspects of performance. And the notice itself, it still has to be a reasonable time frame. And again, it also has to be particularly clear, both the time that's required and also there's consequences of failing to meet the conditions of this notice in terms of time. Now, when one side of the contract is in breach, the other party, if the breach is of either a condition or if they've seriously breached one of the innominate or intermediate terms, then the innocent party there has an election. They can either choose to essentially accept the breach at this point and say, okay, there's been a breach and it's a serious breach and we wish to terminate at this time, or they can elect to keep the contract on foot. And it's important to note here that if you do elect to terminate at this point, just as a rule, a developed rule of contract law, you have to not be, I guess, in default yourself. You have to be able to demonstrate to the court that at the time when the right to terminate arises and the time when you elected to actually exercise that right, you had to be ready, willing, and able to perform your side of the contract. And if you do elect to terminate at that time, then your own contractual duties will come to an end at that point. But if you don't choose to terminate and you wish to essentially continue doing your performance with the idea that you'll sort of seek some form of compensation from the side in breach at some stage later, you still have to do exactly what you promised to do. So your contractual duties aren't discharged at that point. And again, from a very pragmatic commercial perspective, you just try to put yourself in this position that if you think that the other side has breached a condition or made a serious breach of an intermediate term, and you decide to exercise this right to terminate, use caution. And the reason I'm saying that is that if it turns out that you are wrong, then you're the one in breach, and the other side can seek some form of compensation from you. So just be very mindful when doing, electing to terminate a contract, that you've really looked at the underlying facts, you've looked at the contract itself, and in many situations, particularly for large commercial contracts, you've sought some structured legal professional advice as well. So essentially the advice here is just take care when doing this, because the idea of demonstrating or electing to terminate at this point, and if you're wrong, it amounts to what we call repudiation, and that can have some quite serious consequences. Now, repudiation essentially is this expression or demonstration of either an inability or a lack of willingness to actually be bound by either by the contract in entirety or the key obligations as part of that contract. And it's really important to note here that it has to be very clear. Parties that know and understand the obligations in contracts, and I guess also the legal consequences of doing or being the side that's in breach, appreciates the gravity of repudiating contractual obligations. And so the test there, when we're trying to determine whether or not there has been repudiation, is looking at whether the other side, again, through words or conduct, would appear to a reasonable person to be either renouncing all their obligations or renouncing the core obligation or obligations under the contract, these contractual conditions, or basically demonstrating either an inability or an unwillingness to perform the majority of terms, these non-essential terms, but enough that it would really constitute a major failure to the contract as a whole as a result. And again, note that this idea of being ready, willing, and able is important. That if you aren't in a position to complete your obligations under the contract, the fact that the other side isn't actually going to be relevant here. And trying to determine whether or not the other side has done this repudiation, or also known as this anticipatory breach, we look at their conduct. What have they said? What have they done? And where are they at? This demonstrated inability to perform on the facts. So that when you, as the innocent party, are trying to determine whether or not they've repudiated, you've got to look at all three of these aspects. I guess the takeaway message from this, in terms of repudiation, is just to be careful. Make sure that you're very certain that the other side has demonstrated that they are either unable or unwilling to complete their side of the contract before you really take some form of action, particularly with the election to terminate a contract. And also make sure that you are ready, willing, and able to perform your side of the bargain. And this is something that you'll need to demonstrate if the matter does end up going before the courts. Now, the next way to discharge your contractual obligations, and perhaps the easiest to describe and analyze, is by agreement. That's where the parties to a contract that hasn't been fulfilled or completed can just agree to discharge some or all obligations. Now, There are some mechanical difficulties here, and one of those is that contracts by default, they won't actually be discharged, even if the parties do agree, without usually the creation of a new arrangement or agreement between the parties. Now, in that situation, to create a contract, as you're aware, we need to have consideration flowing from both sides. So particularly if there's a situation where one side is discharging obligations of another side unilaterally, you've got to bypass this need for consideration. Usually this is done through a contracts by seal, so that's overcome with the deed system. Also make note that if there is a clearly worded clause in the contract itself, the original contract, you can discharge obligations under that. Again, that goes back to the idea that this is private deal making, and the courts will follow, where possible, what the parties have intended from the outset of their arrangement. Occasionally you see the term novation, usually to do with substituting either obligations in a contract and or parties to a contract. And again, usually that's this is achieved through the creation of a new contract or arrangement or an agreement in order to facilitate this. Another mechanism for discharging contractual obligations, and this one's a little bit more unusual, is what's called the Doctrine of Frustration. And it goes like this. If something happens, something major happens, and the contract becomes absolutely incapable of being performed in the way the parties intended it to be at the start, and it's been radically altered in some way, then at that point in time, at common law, obligations of both parties are discharged. And this is called frustration of the contract, and usually it occurs in situations where something, often the subject matter, has somehow become extinct. And the case here of Taylor and Caldwell involved the hireage of a hall to do some performances, and that was all fine and good. But a couple of weeks before the performances were scheduled, the hall burnt down. Now, the key part to note about frustration is that if the parties actually did contemplate such things happening, then frustration can't apply. If it's something that the two parties had actually contemplated and enshrined into their agreement, this or that's going to happen if the hall burned down, for example, then it's been contemplated. It's not an event that was unforeseen, and as a result, the doctrine of frustration doesn't apply. And the final area of discharge, ways that you can bring a contract to an end, is through operation of law. So either common law rules or statutory mechanisms can discharge contractual obligations. Now, bankruptcy and liquidation of companies, when the trigger event happens that, again, place a person in bankruptcy or a company in liquidation, and the assets become vested in trustee or the liquidator, then contracts that are on foot at that point are by default discharged. Now, you can go and seek to prove these to, again, either the liquidator or the trustee in bankruptcy, but by default, contractual obligations at that point are going to be discharged. There's also an old rule to do with fraudulent alteration of the actual document itself. That can discharge. There's a common law rule that says that'll discharge contractual obligations there when one side fraudulently alters the document. That comes from an old case called Pigot's case from the 17th century. There's also a common law doctrine of merger. That's the idea that if a particular right that was to be accrued under the contract is actually replaced by a superior right, then those two rights will merge. That can just mechanically cause a party's obligations and contract to dissipate as well. And so the classic example of this is where one party has the right to a lease across real property, and then as part of, again, the mechanics of contract law, they've ended up with full ownership, or what they call title and fee simple, of that same area. Those rights merge together. The fee simple estate is, I guess, is the superior right to the lease, and subsequently that any contractual obligations to acquire the inferior right is merged with the superior one. And finally, although not strictly discharging the contractual obligations, if, and again in Queensland this is 6 years, if this limitation period expires, it's not that strictly speaking the obligations has dissolved, it's just that you can't bring the action to court. And so actions for contract and for most torts have 6 years from the right the right to sue arises. For contract, that's usually the point of breach. Okay, now I really want to look at the remedies. What do we get? Okay, sure, contract may be over. What do the parties actually get? Or rather, what does the innocent party get from the side that is in breach? And I guess the starting point is dollars. The default, standard, generic thing that you get as the innocent side from the party in breach, if you ask the court, is what we call common law damages. And the important thing to note about common law damages is that, first of all, they make up the bulk, the vast majority of compensation and remedies that one side gets from another in contract law. And secondly, that if money will satisfy your particular situation, that is what you're getting. There are some other remedies that we'll talk about a bit later that a party can apply for an equity, but they will not be granted if common law damages are going to be adequate. They're actually going to solve the particular need that you have. The basic principle for receiving damages in contract law is that they're designed to put you in the situation that you would have been in if the other side had actually done or performed what they had agreed to. This is a really important rule, and a lot of people, particularly those that haven't studied a lot of law, may not be fully aware of this when entering into contracts, because it's certainly different from other areas of law, for example in tort, where usually it's designed to look backwards in time, to compensate you, to put you back to where you were. No, that's not how it works in contract. In contract law, you are to be compensated to put you in the position that you would have been in. And sometimes this distinction can be huge. When we're trying to determine, though, what the amount of compensation is going to be, the courts sort of separate this into two broad categories. The first category is the one that you use by default, and that is the situation where the innocent party can prove to the court, using some formula or calculation, what they would need in terms of compensate them for this loss of this bargain. In other words, they bring to the court their calculations of what the other side needs to do to compensate them, to put them in the position that they would have been in if not for the other side's breach. And this is contrasted, though, in situations where that can't so easily be calculated. In that situation, you aren't going to be able to get or be put in the situation that you would have been in, but for the other side's breach. Instead, you're going to get back what you've actually spent or outlaid. And so the case examples here of Commonwealth and Oman Aviation and McRae and the Commonwealth, I'll just go over these just briefly. In Oman Aviation, there was a company which had some planes, and they had entered into a contract with the Commonwealth to do some spotting, to do some flying around and surveying and such like. And they spent a lot of money. And the reason why they spent a lot of money, millions of dollars, was that they expected that, sure, for this first contract, yeah, they're going to lose a bit of money, probably going to lose quite a lot of money, but later on, if they get more contracts, they'll be able to take advantage of those. And when this matter did go to the High Court, the Commonwealth tried to argue that, look, well, yeah, sure, we've terminated this at this point, but there was no realistic expectation that we would go and give them future contracts. The High Court disagreed, though. The High Court said that, look, there was always going to be some chance. So they worked out what that is, and they were able to take that into account in order to calculate, again, this future loss and award compensation based on expectation damages. We can contrast that with McRae and the Commonwealth Disposals Commission. There, it's a case we referred to in earlier screencasts. There, the salvage, McRae was a salvage operation, and they were trying, based on information given to them by the CDC, to go and salvage an oil tanker. And there, when this went to the High Court said that, look, in this situation, you couldn't really calculate how much you would have got from this oil tanker. Well, because the oil tanker never existed. And so logically, you can't ask the other side to put you in the situation that you would have been in if the subject matter never existed in the first place. So it's important to note here also that the courts are willing to do some calculations. So, for example, if you were to enter into some form of competition, and you could prove to the court you had a percentage chance of winning that competition, and you were wrongfully excluded from that through the other side's breach, the court can take that into account. And with Howe and Tiffy, that involved a race horse and the lost opportunity from having and running that horse. And in that situation, the court said that, yes, look, assuming the horse had this percentage chance of winning, and this was the total amount of winnings, we'll just multiply those two things together and provide you with that amount as your compensation. Similarly, in Chaplin and Hicks, this was a contest in order to become, I believe, a chorus girl in a particular production. And again, the courts in that situation calculated the percentage chance of getting through to the final amount and the amount of dollars that a person would have sort of received as a result of making the final 8 in that situation. Just make note, in these cases, there seems to be a tendency in the case law to find these percentages to be pretty flat. In other words, if you are actually an incredibly good chess player or bridge player or something similar, and you're denied the opportunity to compete in a particular event, you're probably going to have a hard time convincing the court that your odds or percentage odds were significantly higher than the other competitors in those circumstances or situations. I'm going to look now at some limitations that are placed on damage awards. And the first one is something that the plaintiff always needs to prove. They need to prove this aspect of causation. In other words, they must demonstrate to the court that the particular breach that the other side had led to their loss. It must also be said in comparing contract law with tort law, that the test for causation in contract is usually a lot more straightforward, a lot more commonsensical, and to be honest, usually a lot easier to actually prove. But note that if the party can't prove causation, in other words, they can't demonstrate that the breach of the other side actually caused the loss, the party is still entitled to damages, but they're only what's called nominal damages, a token amount to demonstrate that their rights have been infringed in some way. Another aspect that, again, the plaintiff must prove to the court is that the actual loss or harm suffered wasn't so far removed, or what we call remote, from the breach itself. And in order to do that, they refer to a case called Hadley and Baxendale. And in Hadley and Baxendale, which involved a mill which had a crankshaft in it that required repairing, and the courier took it away from the mill to be repaired, and there was some delay of a few days in returning it, and the courier doing this was quite horrified to find that the mill didn't have a spare crank shaft in that case, and so suffered quite massive losses as a result of not being able to run the mill for an extended period of time. And so when developing this test, the judges in that case said that, look, the real test here is that whether the sides could have foreseen this loss. And the test they use is that either the plaintiff has to prove that the particular loss was something that just arises naturally, as a natural consequence in the ordinary course of events from the particular breach, or that it was something that, when the contract was formed, the parties might have talked about. They could reasonably have contemplated talking about and discussing, as the particular result being, I guess, the probable result of a particular breach. And it goes without saying here that if it was something that the parties actually discussed or contemplated or talked about at the time of formation, you're going to satisfy this test. The difficulty that can arise, though, trying to get some form of compensation where there are going to be some material changes. Now, in the case of Victoria Laundry and Newman, in that situation, it was a company which did professional dyeing for things, and they had got Newman to take some of their equipment away in order to service it in some way. And now, what happened was, again, while the machines were away, that Victoria Laundry had some contracts, some lucrative contracts to score some unusual or new and different work in terms of doing dyeing. And thanks to the delay of the other side, they weren't able to jump on these and actually take advantage of these opportunities. And so they tried to seek compensation there, and the court said no. In that situation, the other side wasn't going to know, and it wasn't reasonable for them to think that either this new aspect of business was something that was going to occur naturally in the ordinary course of things, or that it was something that we might have contemplated at the time of formation. Now, as with the test for causation, if the plaintiff can't satisfy remoteness, it's not that they're not entitled to damages per se. They can still receive what's called nominal damages as a result, but they're not going to get anything substantial. The next area to look at in terms of the reduction of the plaintiff's damages in an action for breach of contract is to do with mitigation. Now, at common law, the judges have developed, I guess for policy reasons, a series of rules requiring the party who is innocent in the contract to actually take steps to minimize the loss of the other side. And at first this may sound a little unintuitive. Why should the innocent side have to do anything in that sort of situation when they're not the ones at fault? But from a policy perspective, the courts don't want parties who are right when others are wrong in a situation with a contract to waste things. And in situations where they can take reasonable steps in order to reduce the loss of the other party, they're obliged to. And if they don't, then their own damage awards are going to be reduced. And it's important to note here that if you do take some reasonable steps and you do actually reduce the amount of loss that the defendant's going to suffer, then you can't claim for that. You have actually reduced the amount of damages you can claim. But you still are obliged to take those reasonable steps. However, reasonable steps doesn't mean that you're going to be perfect. And so that, and again, in this Burns and Mann Automotive was the situation where the plaintiff had bought a truck, a prime mover, and had a trucking business, and had contracted for this truck, and it was argued that the motor in it was supposedly reconditioned. It turns out to not be in very good shape at all. And so the guy used this truck for a while, a good part of a year, and it it was very inefficient. And there was this dispute in terms of the motor being reconditioned or not, and the defendant in this case refused to actually do the reconditioning. And so the plaintiff kept driving, kept running his business, but as a result of it being so inefficient, he lost money, and he continued to drive it to keep losing money. And there the High Court said that, well, yes, strictly speaking, you do win. The other side is in breach. This engine was actually, for want of a better term, stuffed. When you realized that you were losing money, you're allowed to take reasonable steps to try and mitigate loss. When you started to realize that you were continuously losing money as a result of this particular breach, with the engine not being good quality, then you really had to stop at that point. And so his damage award was reduced accordingly. The next area to look at are what's known as liquidated damages clauses. These are also referred to as pre-estimated damage clauses in contracts. It's the idea that, look, parties, when they come together, can determine and try and calculate what the amount that the parties are going to owe each other if they breach particular terms of the contract. And the courts are quite willing to uphold these, if validly formed, because going back to this principle of the courts of common law are not the destroyers of bargains. Hey, if this is what the parties have agreed to, then that's fine. That's up to them. However, what parties, particularly the more powerful parties to a contract, have a tendency of doing is inserting these clauses into contracts, not actually as a genuine pre-estimate of damages, but just to make sure the other side is absolutely terrified of being even slightly in breach. And we call those penalty clauses. And if the courts determine that a particular pre-estimated damages clause is so onerous and so unfair or extravagant in the amount, then it'll strike it out. And then what it'll do is just substitute the court's own common law set of rules for determining damages in that situation. Now, the clause, in terms of analysing whether a clause is either a liquidated damages or a penalty clause, the courts look to a couple of things. They look at the amounts, and really, if the amount that one party is purporting to put into this contract is way out of whack with the absolute greatest loss that they could conceivably suffer, then it's going to be considered a penalty clause. And in relation to contracts involving money, if the amount sort of stipulated as the pre-estimated damage clause is vastly out of whack or greater than the amount of money that was going to be paid under the contract, the courts are also very likely to consider that to be a penalty clause as well. And another situation where a supposed liquidated damages clause is actually a penalty clause is when there is one large amount that's supposed to cover breaches of both the very, very major terms, in which in that situation it might be reasonable, but also to cover breaches of minor terms of the contract as well, small things. In situations like that, the courts are more willing to strike out these clauses because they're penalties. There is a particular set of circumstances, and again this sort of relates to this idea of having pre-estimated damages and penalty clauses, is deposits. It's not uncommon in commercial arrangements to take a down payment, some fraction of the contract price ahead of time. And contracts often have clauses in them that saying that, well, that amount is non-refundable. In other words, if you breach and you don't perform, usually by paying the remainder of the balance, then that 10% or whatever the deposit amount is kept by the seller in that case. Now, the courts, just out of habit and custom, have found that 10% is about right. And this applies to a wide range of contracts. And in situations where parties have sort of requested more than that, 20, 30, 40, 50% for deposits. Courts are far more likely to strike those clauses out as being essentially penalties. And note that you can claim under equity this relief from forfeiture in order to try and have your deposit returned in situations where it is a penalty clause and it's unconscionable for the seller in that situation to retain that money. Now, as well as those three major areas of causation, remoteness, and mitigation, there are some more specific and, I guess, minor restrictions to damage awards that I'll just go over now. The first thing is that contract law is not really about the personalities of the people involved, and as such, you can't get damages in contract law for hurt feelings. Fundamentally, that's not what contract is about. Similarly, you can't usually get amounts back or be able to recover damages for disappointment or distress where things didn't go the way you expected them to be. The idea is that, look, if you have a particular contract and it doesn't go the way you expect it to be in terms of the performance of the party, you can sue for breach, but in terms of quantifying your loss, usually your own disappointment doesn't form part of that. Now, there are some exceptions to that. Baltic Sea Shipping and Dillon, in that situation, a woman, Mrs. Dillon, had bought a ticket for a cruise on a boat called the Mikhail Lermontov, which a few days into the cruise sank in the Marlborough Sounds in the South Island of New Zealand. And there the courts did award some amount for this, again, this loss of disappointment, distress, and that was fundamentally because the heart of the contract was that it was a holiday. The whole idea of going on holiday is to reduce your stress, to make you happy. That's a foundational, a fundamental aspect of that particular contract. And in that situation, that is something that can be claimed or compensated as a result. In a similar vein, damages usually in contract law you can't recover for loss of reputation. However, in situations where a particular contract is actually designed to enhance or increase your reputation, then you can. So in the case of Flamingo Park and Dolly Dolly, that involved a clothing outfit or label that had some prints made through a printing company of some sort of fabric printing company, and unbeknownst to them, the printing company then went and took some of the prints and used them on other designs that they have elsewhere. And in that situation, the plaintiff argued successfully that their reputation was diminished in some way through the breach of the other party in that situation. Another thing to note, and this is an important distinction between the law of tort, and particularly the tort of negligence, and contract, is that at common law anyway, there's no equivalent to what we call contributory negligence in contract law. When a party is in breach, the other side has to compensate that party again to put them in a position they would have been in. Whereas in tort, if there is a situation where one party is in breach, and again, for example, is negligent, there's a particular duty of care exists, and they've fallen below the appropriate standard that duty entails, and harm has come to a person as a result. In that situation, the plaintiff, when bringing an action under negligence, can have their damage award reduced if they were also a little bit negligent throughout the process as well. So, for example, if a person suffers some form of personal injury, yes, if the other side has a duty of care and they've breached it and so on, that you can claim some form of compensation for personal injury. If you were intoxicated, though, your damage awards by default are reduced. Now, in contract law, again, at common law, this concept doesn't exist. However, in the 90s, all jurisdictions in Australia did actually provide a statutory mechanism to allow for this, for a reduction of damages for situations where there is a coexisting duty in tort and in contract. And this kind of makes sense. For example, a professional such as a doctor can be liable to a patient under contract or under tort, but it seems like a bit of an artificial distinction if that doctor is being paid to $10 as opposed to being paid sort of nothing at all, that contributory negligence wouldn't apply in situations where the patient also materially contributes to the harm themselves. The next set of remedies that I'm going to talk about are formed under the area of law known as equity. Now, the important thing to note about equitable remedies, first of all, is that they can only be done by the court. There's no mechanism for self-help in equity. Fundamentally, that flows from the idea that you don't actually get relief from the court by right. It is a discretionary set of rules that are granted by the court. In other words, that the court can elect to not give you a particular set of remedies. And the reason that they would do that is in situations where you have acted with some aspect of bad faith, or you've gone in with clean hands or unclean hands, or you have taken too long to go to the court. They're following these, what we call these maxims or principles of equity. It's also important to note that if damages are an appropriate remedy, the courts will award damages. The default remedy for things in contract law is just simply money. From time to time, though, there will be situations where money is just not an adequate remedy. Now, these situations where, particularly when you want the other side to do what they said they were going to do. For example, if you were to purchase a particular package of land. Now, in situations when there's a purchaser is buying something which is very, very scarce or rare or unique, then specific performance is a technical term that we use to describe this process of asking the court to actually make the other side do what they said they were going to do. In the case of these rare and unique items, to actually transfer title to the buyer in a situation where the seller would otherwise be in breach. And the key thing to note here is that this applies, or at least a party can ask the court in this equitable jurisdiction to apply for specific performance for sales of land. Why? Because the courts for a long time have deemed all packets of land to be unique in and unto themselves. So as a result, in theory, when the other side defaults, the seller defaults, the buyer in that situation, at least from the perspective of the courts, can be in a set of circumstances where common law damages just simply may not be adequate. And so they can ask the court to actually make the other side convey the land as a result of this. And certainly for those that have ever seen a standard form residential transfer of title of real property, there are specific clauses in there actually governing the rules for specific performance. Now, because this is an equitable remedy, though, the courts won't do it if it's going to cause some form of injustice. So the first of these is what we call undue hardship. If it's going to cause a grave injustice through causing, really impoverishing one side as a result, they're not going to grant it. In Norton and Angus, involved the buyer actually in this situation, where the seller wanted to enforce specific performance, but the court said no. And the reason for that was that there were specific rules that a person couldn't own more than one property. So there were two conveyances, and the statutory mechanism in place prevented one person from owning both. So that would have caused some sort of grave injustice here, because that the buyer would have had to have disposed of one of those properties in a hurry. One aspect of specific performance is to do with the mutuality, in that it won't be granted if either party can't enforce it against the others. And where does this arise? It arises usually where one party is a minor. And certainly that's the case of Boyd and Ryan, where a minor was trying to purchase, demanded specific performance, and the courts refused to grant it in that situation. Similarly, and again, for the interests of justice here, courts will not enforce specific performance for contracts with personal service. And the reason for that, it's kind of commonsensical. It essentially amounts to slavery. You are making somebody do something or work for somebody else that they do not want to do. And in those situations, common law damages are the appropriate remedy. It's not specific performance. Also, specific performance is not going to be ordered where the courts are going to have to check at some stage later that the other side was actually doing what they were ordered to. And so in J.C. Williamson and Lukey was a case involving movie theatres and the suppliers of confectionery for those theatres, and there the suppliers who had lost that contract wanted to enforce the right to actually remain as the supplier in these theatres, and the court said no, because we would have to follow up and check that this is an ongoing process, and so here, have some money instead. So while specific performance is an equitable remedy making somebody do something, an injunction can be thought as the flip side of that. It is an order stopping someone from doing something. It's basically prohibiting a party from breach by making them either stay away from somewhere or from time to time making them do a particular task as a result of their contractual obligations. These often arise with restraint of trade clauses, where a party either used to be an employee of someone or there's been a business that's been sold, and the other party is seeking an injunction as a remedy, stopping that party from the party in breach from operating either in a geographic location or within a certain industry. And the case of Warner Brother Pictures and Angolia involved an actress, and again, she wanted to carry on working for one of the competing picture companies, and Warner Brothers sought an injunction as a result. Similarly, in Curra and Beyond Productions, there it was a TV producer wanted to work for a rival network, and they sought an injunction preventing that person from operating, specifically working for the competition in that case. Now, it's important to note here that an injunction won't be granted in situations where it kind of mirrors specific performance, or that's the really only logical result. And so the example here is Page One Records in Britain, and they're the manager for a band called the Trogs, a 60s English rock band. The band didn't want him, so he sought an injunction preventing them from getting another manager. And there the court said that, look, rock bands need a manager, so essentially what you're doing is forcing them to have or take you, and that really amounts to specific performance, and we're not going to grant that. So again, here you go, have some money, go away. And I guess the flip side of that was Buckenara and the Hawthorn AFL club, back when it was the VFL in the 1980s, there was a player who didn't want to play for the Hawthorn, and so they took out an injunction preventing him from playing for any of the other teams. And the argument there, the injunction was granted, and the argument there was that, look, this isn't preventing the guy from playing professional Australian rules football. All it is preventing you from doing so in Victoria. You're perfectly capable of going to the South Australian or Western Australian leagues and playing there. Another equitable remedy is this concept of restitution. Now, this is where one party has transferred money to another, and that transfer has either happened in error, or there has been a contract, but there is what's called a total failure of consideration from the other side. Now, in Fibrosa, there was a machinery company that was selling some Fairbairn being the sellers of machinery, and Fibrosa being the company that was purchasing machinery, and they paid $1,000 of about $5,000 as a deposit. And in that situation, war broke out. Second World War broke out, and so the sellers in that situation argued that frustration occurred. And the rule is with frustration is that the parties bear their own loss. The loss falls where it lies. However, and in that situation where Fibrosa went to the courts and argued, where one party receives absolutely nothing for a contract, there's been a total failure of consideration, and as such, the court can order restitution of that amount back to that party. Now, for a long time, this test was pretty steep. It was pretty harsh. It had to be a total failure. In other words, if one side had started to perform and you got some form of benefit before the contract was frustrated, you couldn't use this doctrine to try and recover money under this the umbrella of restitution here. In more recent cases, the courts have been a little bit more flexible in this and said that, look, if the contract's severable or divisible, the court can actually order repayment for on a component by component base, where there has been, again, a total failure of consideration for each of those components. Another equitable remedy to look at is this idea of quantum meriu. It occurs in situations where a contract was either void, and this can arise through things, for example, like mistake, or where there is an informal arrangement that never actually forms into a contract. So it's where one party starts doing work and the other side gets some form of benefit from this, but there's no actual contract. And the key thing to note here is that the party doing the work can't actually be in breach. If a contract is in existence and they haven't sort of completed their obligations, then they can't use this mechanism in equity to try and ask the courts nicely for some form of money as compensation for the work that they've already done. In the case of Pavey and Matthews and Paul, some builders entered into an oral contract to do some renovations. And by the time the renovation was finished, they got paid, but they only got paid about half what they'd asked for, and about half of what the amount of work that they'd actually done was worth. And in that situation, this particular class of contract, under the particular builders regulations in New South Wales, was required to be in writing. And so as a result, it wasn't a validly formed contract. And this went all the way to the High Court, and the High Court said that no, actually you can still claim that. In the situation where you have supplied goods, you can ask the court, again, it's a discretionary remedy, provided you haven't done anything naughty in relation to the transaction yourself, you can ask them to seek some compensation, and it falls under this large umbrella of what we call unjust enrichment. It would be unjust for the other side, again Paul in this case, to retain the benefit where one side has done all this work, notwithstanding that the contract had defects in that case. And the important thing to note there is that you can't really use this as a sword. It's really just a shield, in that you can't ask for money that was promised if it was more than the market amount. The idea of making a claim under quantum merit is that you are essentially begging the court to apply a discretionary remedy where there isn't a contract. As such, you can only claim for as much as the court is comfortable awarding you for what you actually did.